Good morning. Thanks for everyone for being here. The longer I come, the more I get to know so many wonderful members of the bar and many of you who practice in family law. And just from all of us, thank you, and I appreciate the collegiality that we have with one another. Before I begin the substance of the materials today, I want to just cover a couple of preliminary matters that I feel are important. One is that when you have a firm that has more than a few lawyers, sometimes you have the advantage of being able to conduct training for all of your lawyers at one time. We have the advantage from time to time of having Linda Sheely come out and talk to our office and speak to each of the lawyers that are there and conduct training for us. It just so happened that in the fall of 2015, she conducted a training session with us, which was directly on the subject that I was asked to speak on, which is ethics, the internet, social media, and other things for lawyers. So with a great deal of credit to her and her express permission, she's allowed me to use much of the information that she provides and has provided to our office in order to present some of the material for you today. So I hope you give her credit. She's actually on the program a little bit later today, and she's speaking on ethics and family lawyers, possibly a switch of our roles, but it certainly would be, it certainly is great to have her and her contribution to what we've done here today. Last year, you'll remember, the second thing I want to mention is the last thing you'll remember is, you may recall last year we spoke about Rule 69 in family law settlement agreements. Over the course of the past 12 months, one of my great associates, Lindsay Oliveras, who is with us today, has helped do a lot of legal research for me with regard to updating the materials that were presented at that time. And we've put together about 40 memo decisions and the analysis of those, along with a variety of other case law, and are putting together an article which we hope to be published in the near future. So I'm just suggesting you might keep your eyes and ears open, and if that comes out, it might be a resource for you. I'm hoping that it will become a resource for all of us in using it with regard to family law agreements, particularly with regard to preserving them when we're trying to preserve them and challenging them when we're trying to get out of them. So you can keep that in mind and possibly look for it. I think it'll be of interest, too, to our appellate panel who will be here today at 11 o'clock. So the subject matter for today is called some ethical suggestions with regard to the internet. And I've categorized it as some do's and don'ts regarding technology, and that's how I've put it together. The materials for this presentation appear on pages 165 through 171 of your materials. And there's only 7 pages. They're very brief, and they're very simple and to the point. Obviously, if you're discussing the subject of technology, it's such a broad subject. There's no way, either in 30 minutes or probably 30 hours, we could cover the entire subject of technology and how it affects not only us in the practice of family law, but ethics, or in all of our daily lives and everything that we have to do. So at the back of the materials, I've summarized a list of those resources or references that you might want to read. If you're one of those people that likes to take hundreds or even thousands of pages of material and study it in your free time, then those are some of the articles that I suggest you pay attention to and read. Particularly, I'm not one of those people. I probably don't spend enough time reading it. Sometimes I just don't have enough time in a busy practice. Sometimes I have too many other things that I need to take care of. So I have to ask myself, if I came to this seminar, what is it that I want to know about this subject? What would I want to hear? So I took all of the references and distilled them down into 7 short pages of do's and don'ts that I think might apply to what you want and need to know with regard to your practice about ethics and the internet. The ERs are referenced in numerical order in the materials. They go from the smallest to the largest. And underneath each one of those are a series of cryptic bullet points that just say do's and don'ts about what we can use and what we can't. Some of these may be new to you. Many of them may be just reminders of things that you already know. There's no way that they will cover the subject from one end to the other, as you might guess. So let's take a look at some of those for just a few minutes. Before I start covering each one, I just wanted to make a comment about my personal view about ethics. We come to seminars and we talk a lot about all the different subject matters that we have in family law cases, and those are relevant and important, and they tell us a lot that we can do with regard to our clients. Ethics sometimes is a subject we hate to talk about. It's an uncomfortable subject. It makes us feel a little bit like, okay, the pressure is being put on us. I hope that we can change our perspective a little bit to say ethics is really designed to help us. It's to protect us. That's why the bar comes forward with the rules. So when we talk about these, instead of thinking about them as do's and don'ts or necessarily what I can and can't do and how do I avoid them, think of them in terms of what it is that really is benefiting me. So, ER 1.0 defines electronic communications as a writing. What does that mean to you in your practice? Well, it means that emails are mail, just like every other piece of mail. It means that text messages are communications. And so in our practice, since we have to save our files for our clients, and clients are entitled to have every one of those files and every one of those mails and every one of those electronic communications, you have to save every email that you write. You have to save every text message that relates to a client's case. So, how does that help us? We should be training our staffs, we should be training our lawyers, training ourselves, that they write nothing in a file that they don't want to be seen by a judge or the Bar Association someday. Because there's a reality that that may, in fact, very well happen. If you're at court, your client hasn't shown up on time, or you forgot something out of that file that was really important for that hearing that you're attending that day, and you write a quick text back to your staff and tell them to please run it down to you, that text may be the subject of your file. So you might want to remember to keep all communications that are in those email communications appropriate and worthy of being read someday by somebody else. It's harder and harder in our practice, if you've noticed it, or at least I feel it this way. It's harder and harder to carve out privacy. More and more of what we do becomes the subject of somebody else seeing what we do. You can't write an email to your staff anymore without thinking it's going to be given to the client. You almost have to worry about telephone calls. What happens someday when our telephone calls are all going to be exposed to somebody, or our conversations? Narrower and narrower the things that we can do that don't have to be preserved. So beware of that as you're conducting your practice. ER 1.1 subsection 6 requires lawyers to be competent in relevant technology. We do not have to be expert IT fellows such as this wonderful gentleman that's sitting over here conducting our seminar today. But we do have to hire personnel who know what they're doing and are competent with regard to the ethical rules that we have to follow. That's the do of that subject. ER 1.6 requires confidentiality of client information. This is a big one with regard to lawyers, especially for those who might have practices where they decide to store client information on an outside remote source, such as cloud. If you do that, Linda has provided, and I've copied off, 7 particular rules that you need to do to verify the source, because you have to take reasonable steps to investigate the provider's security measures before you're allowed to store a client's information on that source. So those 7 steps are listed at the bottom of page 2 and the top of page 3 of the materials. You have to warn clients about communicating with staff informally on Facebook. You have to have a written policy in your firm with regard to what happens if those who have access to firm information on their recording devices have either lost their device, it's been damaged, or it's been stolen or misplaced. You have to have every person who has an electronic device with electronic material on it have a password that's secure, so that if it gets lost or stolen, it cannot be accessed for client information. That's how you protect it. One of the thoughts that was raised by a very good litigator in some of the materials was if we're disclosing electronic information like we often get. One of our clients brought in a thumb drive the other day with 800 pages of documents on it and said, here it is. Before that's ever disclosed to the opposing side, you have to review everything that's on that electronic device. Make sure that there's no privileged information, no communications between the client and you, or that you don't want to have revealed to the other side that might not be relevant to the issues in the case. If a negative online review has been made of you, you're not allowed to tell all about your case when you respond, because you're revealing information that relates to confidential information of the client. You should prohibit all of your staff, lawyers, and vendors from posting any information that they receive regarding the clients on any social media sites. ER 1.15 requires safeguarding of client property. We all know what that means with regard to paper documents. We've been doing that for years. But you can also store files and other documents electronically. If you do that, you must provide a warning to your clients about possible third-party access and you must obtain their permission in order to do it. So a good practice tip is make sure your fee agreements have something in them about storing client data in that way and advising them accordingly. Fee agreements is a good place, or representation letters, to take care of most of these items. ER 1.7 and 1.8 address conflicts of interest. How does that apply with regard to some of our social media? We have to train our staff, and we have to know as lawyers that we don't go on Facebook and start talking about our cases. We don't friend the witnesses or the court staff or other personnel when we're talking about cases. ER 3.3, 4.1, and 8.4 require candor by lawyers to everyone. We are lawyers 24/7. We are required to be honest 24/7. How often have we seen a news item come across the screen which has a lawyer in it, and they're held to the standard of being a lawyer, and the mention of the lawyer is going to be made whether they're in the practice or at a social event or some child's basketball game on a Saturday afternoon? So when you're talking about anything with anybody, you always tell the truth, particularly online or on a social media device. Warn your clients that they are not allowed to delete any of the information that they acquire with regard to the case, particularly on Facebook or other social media or other devices. Remember, there are sanctions for doing that, and spoliation of evidence is the consequence, which has not only sanctions but damages that can be awarded for the failure to comply with that rule. Don't allow any of your staff or private investigators to lie about anything. If you do a background check on somebody, they cannot lie in the process of doing the background check. If they're doing it, they have to make sure they tell only the truth, or it will come back to haunt you. ER 4.4, addressing misdirected communications. We all know the rules, but we'll remind us today. If you get something that wasn't intended for you, or you send it to somebody else and they get it, there's to be stop of the reading. Do not use the material, and notify the sender. Every one of us by now has at least had one or two of those that have happened somewhere along the way, and that's the way we should be operating. Provide regular firm training on internet scams to your staff so that they know and they don't open them up or allow confidential information to be disclosed. And one that's happened to me at least twice in the last 12 months is you're in trial, you've invoked the rule, the witnesses are all out in the hallway, and you take a break. 10:15, 10:30, judge says, let's take a bathroom break. So we go outside and find out that the people in the gallery have been texting all of the witnesses outside in the hallway about what's been going on in the courtroom. If you become aware of that, you have to make sure and stop it from occurring, because you're violating the rule of disclosure by doing that. So be aware, that's one of the consequences that we do with the rule. I want to spend the remainder of the time. How much, Barry, how are we doing? Anybody know? Good. Okay, good. I don't want to abuse the time today. I put together 5 little areas that have to do with this subject matter that I thought would be interesting for us to discuss based upon current developments in our field. So, the question that I raise for you today is, can you serve a petition for dissolution through Facebook? The answer is yes, in some jurisdictions. What are the conditions that you can do to do that? First of all, you meet the criteria for the alternative method of service and ask the court to approve that method. Second, you probably have to serve by another method. I'm not talking about personal service, but some other method in the majority of jurisdictions in order to allow service by Facebook. Third, you have to repeat the service method again. In other words, do it more than once. And last, you might have to leave a phone and a text message in addition to service by Facebook. Boy, doesn't that sound weird compared to where we've been in the practice of law for all these years? Well, in New York, and I can't pronounce the name of that case, in 2015, I do know the word blood in the case, and it's probably an appropriate one for that particular method of service, but those are the facts. I will say to you that that case is an excellent summary of all of the different jurisdictions, the methods, the ones that allow service by some alternative method, the ones that don't. And it also gives a biting criticism of our service by publication because it says it's old-fashioned. And in today's world, service in a publication of a newspaper that people don't even read is probably the worst method of trying to get a hold of somebody if you're trying to serve them with a petition for dissolution. Facebook, text message, other methods are often much more reliable and we would expect somebody to actually read them. Second subject. A family lawyer, unhappy with certain rulings she received, assisted a mother by setting up a social media campaign against the father and the two judges in the case. I don't think I have to go very far before you already know the answer to what happened to this particular lawyer. She argued that she was just attempting to help the mother get her voice out there and was protected by her First Amendment rights. Agree? No. She was disbarred for 3 ethical violations. First, improper ex parte communications because she was trying to influence the bench by communicating with them through social media. Second, she was disseminating false and misleading information about the case because she was talking all about the things that the case didn't really have as part of its evidence. And last, obviously, the general one, the conduct was prejudicial to the administration of justice. Interestingly enough, in that case, the bar recommended a 1-year suspension. It was the Supreme Court of Louisiana that disbarred the lawyer. We often talk about the Nash case for the purposes of child support with a high wage earner. But as Keith mentioned briefly yesterday, and many of you may know, it has a section at the end about parenting time. Does a parenting agreement prohibit disparaging comments about the other parent to the children? Does it prohibit those comments on social media that may not be directed at the children? On the day of the Nash divorce, the mother tweeted a biting criticism about Steve's integrity. The PC cautioned the mother and told her to knock it off. The court said, "We agree," and told her to knock it off. She claimed her First Amendment rights. Notice a theme coming about these cases? Did the court accept it? No. The Court of Appeals rejected the mother's argument and upheld the order even though her criticism was not directed at the children because the comments were, quote, likely to make their way to the children, end quote. Now, think about that one for a minute. How many times do parents talk negatively about another parent where the comments might, quote, make their way to the children, end quote? Probably more than that tweet. So now we know where the case law will probably be going as we go forward. Number 4, when we talk about spoliation of evidence and destroying electronic information, when is the spouse reasonably put on notice that they can anticipate litigation for the purposes of that claim? Remember, the claim triggers when they have reasonable facts that lead them to know that it might occur. Is it when they find the business card in their husband's pants when they're doing the laundry from a family lawyer? Is it when they separate? Or as one of the authors has posed, can a husband destroy photographs taken of him and his paramour? Or another author has posed, can a wife erase incriminating emails, texts, or tweets without fear? So you have to remind your clients and yourselves, when did the claim attach? And it's not necessarily simply when the petition is filed. All of us should be advising our clients not to destroy any type of social media once their client has been served or case law put on notice. Last, can meetings, conferences, and conversations be recorded? How many of you had the experience that I had in the last 12 or 14 months where your client comes into the initial conference and wants to record everything you're saying because, you know what, I just can't remember all of this information when I get home because you're going to tell me so many things that I need to be able to recall them. Or they bring a friend with them and do the same thing. Or what happened to me is I met with the opposing party who was representing himself, came in for a settlement conference because he didn't have to necessarily want my client to be present. So we met. I find out 2 hours later that he tape recorded the entire conversation that we had. So we need to be aware that those things can occur. Can they be recorded? Sure. But we should always assume that the meetings and the conferences and the conversations we have are being recorded. I suggest to you every time you talk to your client, the opposing party, their lawyer, or anybody on that case, you may be being recorded. Warn your client about waiving the attorney-client privilege and that if they've waived it, their spouse will know everything that they've told you if they record it and share it with somebody else. If the opposing party records you, remember that you will have no control over the usage, content, or of the recording if it is edited. So what might you do? You may want to record the very same meeting so you have a record of what is actually being said. We all know that we're not supposed to be recording our colleagues without telling them and having their permission in advance. However, there is a very, very limited exception if you believe that your colleague is going to lie or you've made an agreement that may not be upheld. So be aware of that one. We done? Okay. Do we specifically need to have a disclosure statement on our email? What do you think? I'm not sure I totally understand what the disclosure statement means. We certainly need to have information. Does anybody want to clarify the question just a little bit? Yes.
There's a paragraph a lot of people put at the bottom of their emails, what should look like. There's a need to be one.
There needs to be one, but Linda Shealy will tell you it should go at the top of your email, not at the bottom. Because if you wait till the end, it's too late. All right, let me summarize very briefly. You know how many changes there have been in the practice of law since we started? One of my partners just had his 40th anniversary, Barry Dickerson. And we had a meeting in our firm and talked about his 40 years of practice. Thank you, Jim. When we started practicing, we used manual typewriters with onion skin paper and carbon paper in order to make copies of whatever we were doing. When we started, we used to do handwriting of all of our motions. Even briefs to the Court of Appeals were done in handwriting. It wasn't only until later that we took belts and put them on long cords about machines that we could put in to record what we were doing in order to transcribe the information. When we talked about computers at the time that I was in law school, computers were for great big companies that had big glass rooms that had a computer inside of it with people all walking around in white clothing with gloves on. And that's what we talked about as having a computer. Now, every year, technology expands by leaps and bounds. It goes and grows exponentially with everything that we really do. It's not only making it much easier, for which we're very grateful, but it's also making it much more complicated for us to practice law. And those who've been around for a long time know how much more complicated they feel. The wheels keep turning every year we deal with technology. So when you study the principles, I hope that you try to keep up not only with all of the new things that come up as best you can, but I will tell you, if you stay true to the principles that you know to be right and wrong, that will help you tremendously in doing these things. And you'll be able to not only protect your client's interests, but as I look at ethical rules, to protect yourself. Thank you.